Hold on, let me record this first. I don't know how this works. So if some other people don't get it, then that's on them. Okay, where's the little thingy? There's the little thingy. Cool, do y'all see it? Fine? Cool. So these rules are the who knows what evidence rules and what people can testify to. So we'll get into a little bit about like lay witness testimony, just your everyday average Joe person who just like on the street who saw something or heard something or smelt something. Um, and then we're going to get into like the actual like expert testimony of like the people who pick up like the DNA or like people who start testifying as to what people are thinking, and that gets a little messy, but we'll go through that right now. So the first rule that we're going to talk about is 602. This is the need for personal knowledge. So I'm going to go ahead and read the rule. So it says a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony, and this rule need not apply to witness expert testimony under Rule 703. So you can ignore that last sentence. We'll talk about that once we get to the expert stuff. So the expert stuff is usually like the 700 rules. But basically what this means is like the witness has to know the stuff. They can't just kind of willy-nilly start making up stuff and then be like, yeah, I know that her favorite color is blue. It's like, how does this witness know that? Like, you might know that from other sources, like maybe you told me that your favorite color was blue, something like that, but you can't just kind of get into a person's head and know that certain thing. But let me give you some more examples because that's probably still not 100% clear. So these are just a couple of examples that cover lack of personal knowledge. The exceptions, or I should say that need for personal knowledge in 602, this is where like speculation and lack of personal knowledge, these are where the objections come from. A witness is speculating if they don't have the personal knowledge, or if you object to lack of personal knowledge, well, then you're basically saying, again, the witness doesn't have that personal knowledge to be able to testify to it, right? Let's go to the examples now. So now, if you're not present for something, you don't have the personal knowledge. If I was there and I personally saw the car pass this, like the red light, it was speeding and it passed the red light, then I know that, right? But if I wasn't there, I can't just testify to be like, yeah, I know that that car passed the red light and it sped over it, right? So this is something that happens sometimes subtly. So your listening has to be very like good on this, because a lot of times it's not that obvious, where it's just like, I know that this car passed the red light, and you're kind of like, what? How does this person know that? A lot of people disguise this as, I learned that the car passed the red light. Well, how did this person learn that? So there is something that's kind of funky there, right? How does this person know that? How do they learn it, but they weren't actually there? A lot of witnesses learn this through hearsay. So I was told by someone that the car passed that red light. And so there, a lot of times people object to objection, lack of personal knowledge, and objection hearsay, right? A lot of times when you're reading like witness statements, it'll say something like that, like, oh, blah, 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 this person told me this. It's not to say that that's not possible. Like you can't say like, I learned that the car passed through like the red light. You just have to have an exception for that hearsay statement potentially, right? Because you can learn stuff through people telling you, or you can see like videos of stuff, but ideally is that you personally see it, or you personally hear it, or you personally smell it, or whatever the senses are. Another example is how fast the car was going. So even if you were there, you can kind of say very loosely, like the car looked like it was going faster than the other ones. But you can't go and like go the extra mile per se and say the car was going 55 miles an hour or it was going 100 miles an hour, because I don't know if your regular everyday person would just have that knowledge to be able to look at a car and say it was going this fast. Like give me like 76 miles an hour. I just saw the car and I knew it was going that fast. It's like, well, that doesn't seem realistic, right? There's a lack of personal knowledge that this witness has. If they're an expert, they might be able to say that based on other underlying foundation, other like knowledge that they have because they went to school, and like they can say like there's these tire marks, and based on like where the accident happened, if there was an accident, they were going this fast, because this caused this amount of impact type of situation. But your regular everyday person, same thing, can't really tell you exactly what it is. Similar to kind of how airplanes work, right? If you were to ask someone how like a regular everyday like airplane worked, they might be able to give you loose strokes, but you can't expect the person to know that. They just don't have the personal knowledge. But again, if you ask an an expert on airplanes, they probably can tell you how an airplane works, how fast it can go, like the mechanics of it, the engine, that kind of stuff, right? How it flies, why does it fly, type of situation. So these are just a couple of examples. Questions on 602 so far? So the differentiating factor too between like speculation and lack of personal knowledge that I like to think of is speculation is like the act of actually doing something. So if the witness is speculating, the witness doesn't actually know the answer, but it will give you an answer. Like the car was going 55 miles an hour, right? Well, the witness is speculating. The witness doesn't actually know. He's just an everyday Joe. He doesn't know that. Lack of personal knowledge is like if there's no way in hell this person would know that that car was going that fast or something. Like it's just kind of more like a state of being. There's no way if you ask the question, how do airplanes work? Then you would object lack of personal knowledge. Before like the witness actually testifies to like how the airplanes work, you just object lack of personal knowledge. If the witness goes on to testify, oh, airplanes work like this, work like that, then you can object to speculation because they actually maybe don't know. Or there's a lack of foundation objection because if the witness does know, well, then we need more foundation to establish that how the witness knows, right? And that would probably kind of lead into the expert stuff that we're going to talk about in just a second. So 701, this is like the lay opinion testimony of what people can do or what people can say. So if a witness is not testifying as an expert, this is your regular everyday person, testimony in the form of an opinion is limited to one that is rationally based on the witness's perception. It's helpful to clearly understanding the witness's testimony or to determining a fact and issue. And C is not based on technical, scientific, or other specialized knowledge within the scope of 702. So the first one is rationally based on the witness's perception. This basically deals with like the five senses, right? You saw it, you heard it, you smelt it, you touched it, type of situation. Like you rationally as an everyday person, you were able to perceive it. B is basically just kind of like a relevance prong to make sure like whatever you saw or whatever you felt or whatever you heard is actually relevant and you're just kind of not spouting whatever just to spout something. And then C, it kind of leads into the expert stuff where an everyday regular person can't tell you any scientific or technical knowledge if they don't really have that like background to tell you that, right? I'll give you some examples of how this works right now. So again, it's like the five senses. You can describe you can just describe languages. Sorry, describe language. I don't know what that means. Basically, what you heard, you can describe colors, smells. So that's like your everyday, what you heard, what you saw type of situation. Earlier, we talked about the car going fast. Cool, you can describe that the car was going fast, but you still might need to lay some foundation to say like, how fast was the car going, right? So you can still object to lack of foundation. Yeah, the witness might rationally be able to perceive that the car was going fast, but like you might have to lay the foundation of like, well, how do you know the car was going fast? Well, I know the car was going fast because the other ones, like it like sped past 3 other cars, right? Or like if a person is sitting at their house and like they like to watch the road, they see cars pass all the time. This time, this car was like leaving skid marks and like tire marks on the road type of situation. It was maybe swerving in and out of the cars, right? So you still have to lay some foundation, but you can still get away with saying like the car was fast, right? This one, the guy was drunk or like a person was drunk, is sometimes is a little harder. Depending on the judge, you'll have to read the judge and kind of figure out what they like. Some are very open-ended with this with 701 and like this was rationally based on the witness's perception. This isn't based on any scientific knowledge, right? You can kind of look at a person based on just you being a person and kind of determine like, oh, they were swaying back and forth, their eyes were red, they smelled of alcohol, therefore I determined they were drunk. It's not necessarily any like scientific or like technical knowledge that you would have. Like you're not there like testing their alcohol level, like, oh, I determined based on their BAC level that they were like in fact drunk. Right? It's just based on your perception. And you're allowed to talk about your lay opinion testimony, your lay opinion pursuant to 701. So a lot of times people object to certain opinions or certain things that might sound like speculative, but you can use 701 to fight it, to say something along the lines of like, they object, objection, hearsay. And then you can say, Your Honor, this is not hearsay because it's not based on any scientific, technical, or specialized knowledge, right? This is, you're specifically using and quoting the rule. It's not based on any scientific, technical, or specialized knowledge. It's only rationally based on the witness's perception as what they saw or how they were acting, right? So that's kind of how you can combat it. But you can also use it to bolster your objection, right? So when you're arguing, objection, Your Honor, speculation, and then you ask, may I be heard? And then the judge will be like, yes. Why is it speculation? Your Honor, this is based on scientific, technical, or specialized knowledge. The witness doesn't have that requisite knowledge. It's scientific, therefore she can't testify to it, and it's not rationally based on the perception, right? It just sounds more impressive when you can cite the rule behind of what you're doing. That makes sense? Cool. So questions on speculation and lack of personal knowledge and kind of how those interact. Any, by the way, you can stop me at any point if you have questions on anything. And it's just like, I don't quite understand. But so far, making sense-ish? Cool, alrighty. All right, so testimony by an expert witness. So expert witnesses, usually they need to establish 4 prongs to qualify them as an expert witness. So when you're directing a witness, you have to establish these 4 prongs. And once you establish these 4 prongs, they're basically qualified as an expert. Sometimes in the real world, you will do this outside before trial, and you just kind of very loosely talk about some of these prongs during trial, and then you're done. In mock trial, you do them during trial, during our mock trial, and sometimes there's this thing called voir dire. I'm not going to go into that right now. That's more advanced stuff, but it's usually you just lay the prongs, and then the witness gives you like their opinion, and then they talk about why they came to that opinion type of situation. So let me read the rule. So it says, a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion of other or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand evidence or to determine a fact and issue, right? So that's just basically saying they have some type of specialized knowledge and it's relevant. That's what the first prong is. The testimony is based on sufficient facts and data, meaning they didn't just kind of throw a conclusion out there and had no basis for it. Like they definitely had enough to come to a conclusion. The testimony is a product of reliable principles and methods. They used some type of method or product that's like kind of usually accepted in the field. Usually that is, it's not just like they made up a method right on the spot and like now all of a sudden they're applying it. It's kind of like, oh, I just brought up a random expert or I made this person an expert because they just made up their own method, right? They have a method there that they're applying and they reliably applied that principles and methods to the case, which is the last prong, B, right? Let's see. So Professor Josie, how do I go about doing this in my direct? Well, it's a great thing both of you asked that question. And it's a good thing Professor Josie is prepared and also has an example from his direct last year. So Professor Josie is going to show you, if Professor Josie can figure out how to screen share this, screen share this situation right here. Y'all see that? Yeah, so this is a direct, right? This is kind of how, if you're directing an expert, kind of how you will somewhat structure this. So a lot of times you start by introducing the witness. This is what your name is. Okay, what do you do for a living? So for this guy was an expert in computer technology and automobile investigations. And so he was basically kind of like a forensic automobile guy, right? And then you usually lay foundation about like where they go to school, if they went to school, what kind of background they have to be able to qualify themselves as an expert, right? So they talked about their how they got a BS and then a master's from these schools. If sometimes you ask to testify, if they've testified before, this kind of helps bolster the credibility. You ask if they're published. These are things that kind of like, well, I'm not gonna throw case law at you right now, but there's Daubert there that eventually, if y'all take evidence and y'all get knowledge about that, then these are some of the principles that are talked about in Daubert, which is the case law. It's like the Supreme Court case law that talks about experts and their testimony. So here, this is where we start getting into those prongs that we talked about, the 4 prongs. So like, what materials did you review? And was this enough information to come to a conclusion in today's case, right? I don't know if you all remember that I talked about, did you have enough sufficient facts and data to come to a conclusion? So this is just, these two questions are basically exactly asking that. These two questions, right? But they're more lay person's terms. You can ask that question like, did you have sufficient facts and data to come to a conclusion? But a lot of times I might just go over like a jury's head, and it's a lot of times you want to be a little more conversational. What methods did you use, right? This is we talked about experts need to talk about their methods. Okay, well, this is the method that they use. They talk about the method, and then they talk about, is it reliable? Yeah, it's the standard in my field. That you didn't just make it up. It's not something that's like the first time he's ever used it. And then did you apply it to this case? Cool. After we met all the prongs, now you can talk about your conclusion. If you don't meet the prongs, then you can object. This is what you would say as an improper opinion. That's what, hold on, let me see if I can go back, share screen to this. That is not the right screen that I wanted to share. Wait, am I showing the right thing? No, I'm not. Wait, no, yeah, you are. Y'all are seeing the expert witness stuff, right? Cool. So you have to meet all these 4 prongs in order for the witness to be able to give you their conclusion. If they don't meet these 4 prongs, right before they give you the conclusion, they're going to say something like, all right, professor or doctor or Mr., Mrs., whatever they are, but they're supposed to be, they think they're an expert, then you jump out of your chair. Well, I guess you don't, because you're probably going to be doing Zoom stuff. But you say, objection, improper opinion. And then you go on to state your basis. Usually you ask, may I be heard? And then the judge will say like, yes, why is this, an improper opinion? And then you say, well, Your Honor, opposing counsel did lay the foundation for A, B, and C, but we still haven't heard how, if the expert has reliably applied these principles and methods to today's case. Therefore, we can't hear the expert opinion until the foundation has been laid to show that, right? So that's kind of how you go about, if they miss one, for example, they missed D in my scenario, but they could have missed A, or they could have missed B, could have missed C, right? They could have missed any of those principles. You just have to be listening and make sure you're like checking them off and be like, yes, they met this. Yes, they met this. Yes, they met this. Oh, snap, they forgot this one. Okay, I'm gonna like object, right? And that's just kind of how you go about doing experts like that. And of course, if you're directing the expert, you have to make sure you hit all of those, or else they're gonna do that to you. They're probably gonna object to you. Which I think you might have had a question.
Yeah, I was gonna ask, I mean, I'm not, for the internal tournament, I don't have an expert witness, but it seems like, do you use about the same question, the beginning questions to establish all these criteria? Do you use about the same questions every time you have an expert witness, or are they like very tailored?
Yeah, no, they come somewhat formulaic. It's just depending on kind of how you choose to structure your direct. But you have to hit all of these, right? So they become pretty formulaic in the sense where like they introduce themselves, they tell you what they do for a living, they tell you their education, their background, if they testified before, if they're published, and then you kind of go into like, oh, this is like, what methods did you use? Did you apply those methods? Did you have sufficient facts and data, right? You get all of that stuff, and then they finally start talking about like their conclusion and why they came to that conclusion and what they used to come to that conclusion, right? So usually like the first chunk tends to be very formulaic every single time. But during cross too, can you guess what happens? Like they just attack these prongs a lot of times. It's just like, oh, well, you said you'd use this method. Well, isn't it true that this, and this about this method, right? Sometimes they'll have that. Sometimes they'll attack that the fact that they don't actually have the sufficient facts and data. They don't flat out say that, but they'll say like, oh, well, you would agree that it's important to come to a thorough conclusion, right? And you would agree that it's important to have all the facts and data when coming to a conclusion, right? Yeah. And you looked at this and you looked at this and you looked at this, right? Yeah. But you didn't look at this and you didn't look at this and you didn't look at this and you didn't look at this, right? A lot of times this will come up as in like factors that they missed, right? Or maybe some experts will be like, oh yeah, but I didn't need it. So again, it's your job to show that these were necessary, or like any expert would have looked at these factors, or at least even if no expert would have, you just make it seem very important to the jury. So it's like, oh, this expert doesn't know what they're doing. Look at all the stuff they missed, type of situation. Cool. Questions on this before we move on to 703? No, we're good for right now. All righty. So yeah, cool. So 703. 703 is, there's basically one function for it, and I'll explain right now. So an expert may base an opinion or facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted. But if the facts or data would be otherwise inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value is helpful in the jury, is helping in the jury evaluate the opinion substantially outweighs the prejudicial effect. So what this rule is primarily used for is to get around hearsay. This isn't like the traditional like hearsay exception that you would see in like the 803s or the 804s, right? Or like an admission by like a party opponent. But I can give you an example of like, let's say a psychologist is making like a mental diagnosis of someone. And everything they're probably going to be using is whatever that person told them, right? And any expert in their field, any expert psychologist would be using whatever that person told them to come to a conclusion about their mental health. And sometimes like they might be useful to hear whatever like that person said to them, because otherwise you're not going to know how this expert came to that conclusion. You're just going to say like, oh, they're emotionally unstable or like they're mentally not stable, and that's it. And it's just like, okay, I guess I can take your word for it, but it would be much stronger if I actually have the underlying reasons of like, he told me this, he told me that, he told me this. And based on like everything that he told me, I use my expert opinion to come to the conclusion that he's mentally unstable, right? Normally that he told me this, he told me that, he told me this would all be hearsay. But again, you're not using it for the truth of the matter per se. You're using it through 703 for like the expert to come to their expert conclusion, right? This is where the expert was been made aware or personally observed, and the experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject. And they need not be admissible for the opinion to be admitted. But they can be made admissible as long as they are more probative than the prejudicial value, right? This is like the reverse of 403. I don't want to like confuse y'all, but this is the inverse of that. So if the probative value in helping the jury evaluate substantially outweighs the prejudicial effect. So it has to be very useful, and it has to outweigh the prejudicial effect. For example, I can think of, there's a psychologist that's diagnosing a little kid, and she's saying, this guy is a psychopath, right? The kid is on trial for killing another person, right? And so she's bringing in all these like what would, I don't want to confuse y'all with character evidence, but would be used as character evidence otherwise. But she's not using it as character evidence. She's only using it to supplement her opinion of why she came to the conclusion that that he's a psychopath. There is a balancing test there, whether the probative value of that information that she learned and that information now being presented to the jury to show that this is how she came to her conclusion, if that is substantially more probative and outweighs the prejudicial effect. If y'all went to where I think Jonathan talked about 403 is substantially more prejudicial than it is probative. To kick something out, if something has to be substantially more prejudicial than it is probative, that's when you object to that, right? So this is like dead bodies or like Nazis. I don't know how much. Did both of y'all go to that, or y'all know how 403 works that way? I can give y'all like a little something about it. Do y'all want that or no? Yeah, okay. So 403, it's, let me see 403 says, let me just pull it out. Hold on. Screen sharing, is that okay? Cool. Let me see if I can pull this out. Okay. Cool, can y'all see that? Ooh, it's probably a little like small, right? Let me see if I can zoom in.
Not on my curved screen.
Can y'all see it? Oh,
Yeah,
wait, it's on. I'm an idiot. There you go. That's probably much better. right? So this is 403. So the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing of the issues, misleading the jury, undue delay, wasting time, needless presenting cumulative evidence, right? So here, 403 works in if the probative value is substantially outweighed by one or more of the following, right? Unfair prejudice. The rule that we were just looking at was 703, it flips it on its head. So I don't want to confuse y'all, but if we scroll down, well, actually, let me still talk more about 403. So normally everything that's relevant comes in, right? But there's some like evidence that if it's like so bad that we want to object to this because it's substantially more prejudicial than it is probative. The example that I always like to give is like the Nazi example or like the KKK example. So if you learn you're in like a trial where there's a person who was murdered, it was a black person, right, or a person of color that was murdered. Cool, not cool. Well, you know what I mean. That's the scenario that's happening right now. The person being on trial is a white male who potentially is accused of killing this person of color. You learn through the testimony that this person is a member of the KKK. It does make it, in fact, more likely if he's a member of the KKK that he probably killed him because of the color of his skin or whatever, right? But the probative value there is substantially outweighed by the prejudicial effect, right? Where it's just like, it's so bad that you like this factor, just hearing that he's from the KKK would probably bias the jury so much that it'd be like, you know what, he's guilty. He's part of the KKK. Screw that guy. He should go to jail anyway. Even if like all the other evidence shows that this guy actually didn't do the murder, didn't kill the guy, but you just hear that bad, right? So it's a balancing test. If the probative value and the prejudicial value are equal, then you don't kick it out, right? It's fine. Likewise, if like so this is only if the prejudicial effect substantially outweighs any probative value. Cool? That really makes sense? So that's when you object to substantially more prejudicial than it is probative. The inverse happens at 703. So it has to be really good. The other thing has to be really bad to kick it out. For 703, for your expert to talk about it, it has to be really good for your case, and there can't be that much bad to it. Does that make sense? I can bring it up again. 703. Right here. The proponent may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. And again, this is just basically to kind of get around the hearsay stuff. Usually that's how most people use it. Cool, makes sense so far?
Question about 403.
Question?
Sure. You said substantially outweigh. So usually how high of a bar is that? You know, because I think that there's a lot of people who there's something bad in their background, but does it have to be like, oh, that person was a Nazi, like that bad for it to?
It usually has to be pretty bad, because the balancing test, chances are there's going to be bad stuff about the person, right? Everything that's like harmful towards you is not necessarily going to be substantially like outweighed by any prejudicial effect. There's going to be bad stuff, and just because it's a bad stuff against you doesn't mean it's just automatically getting kicked out, right? But so that's why the burden is so high that it has to be substantially outweighed by any like prejudicial effect. So if like both sides say like, this is really bad for me, but it's also really good for my case, therefore, you know, it gets in. The opposite is like also true, obviously. If like it's very probative for your case and there's little prejudicial effect, then obviously it comes in. The only scenario where it comes, or where you can kick it out by you objecting, Your Honor, this is substantially more prejudicial than it is probative, is when the prejudicial value substantially outweighs any of the probative effect, right? So that's why it's also, some people just say, Your Honor, this is more prejudicial than it is probative. And like that might be true, but the standard is actually substantially more, right? So I always make sure that what I'm saying is like, Your Honor, this is substantially more prejudicial than it is probative. Some people just say, Your Honor, this is more prejudicial than it is probative. And it's just like, yeah, I guess it might be, but I feel like if you emphasize it too, especially if you're the one being objected to, you want to emphasize that the standard is high, right? If they want to kick out your evidence that you're trying to bring in and they're objecting to 403, like they're saying, Your Honor, this is substantially more prejudicial than it is probative, or if they just frame it as, Your Honor, this is more prejudicial than it is probative, you come back and say, Your Honor, the standard is it has to be substantially more prejudicial than it is probative, right? Or else like they can't kick it out. there's more rules that are kind of tied into 403, like confusing or misleading the jury, wasting time type of situation. So like this is also like a cumulative thing, but I think Jonathan probably talked about that too. So if y'all haven't seen it, I think we should be uploading the recording soon, or it should be already up there. I'm not sure. We'll talk about that when we get back into the regular room. Cool. But anyway, any more questions about that? No, we're good? Okay. Almost done. And then last two rules. Cool. So we talked about 703, how it's mainly used for hearsay if people get around it, but it's not just lets you get around it willy-nilly, right? You can't just be a conduit for hearsay. You can't, the expert just can't start saying like, in my example, like, okay, these are the psychologist was talking to the kid, and these were like the factors that the kid told her or him that led to the conclusion of the psychologist diagnosing him as a psychopath. The psychologist then can go and said, oh yeah, he told me about his mom and how his mom likes the color or something like that, right? Because it's just like, that has nothing to do with your diagnosis. And now you're trying to just come around this using 703 and you're trying to see like, oh, Your Honor, this is through 703. The witness can testify to hearsay or otherwise an inadmissible hearsay. It's like, no. It has to relate to the conclusion. If it's not to the conclusion that the witness is testifying and it doesn't meet that balancing test, then you can't bring it in. Cool. So make sure y'all push back if someone just were to decide to, oh, I'm just going to bring this in. It's like, none of that. Trying to pull a fast one on me. Opinion on ultimate issue. So this is most often used when there's like couple elements in like a trial. So let me read it first. So in general, not automatically objectionable. An opinion is not objectionable just because it embraces an ultimate issue. And an ultimate issue is like the actual outcome, whether guilty or not guilty, or like any element of like the crime or like the charge. An exception, in criminal case, an expert witness may not state the opinion about whether the defendant did or did not have the mental state or condition that constitutes an element of the crime or the defense. Those matters are safe for the trier of fact alone. So the jury has to decide whether or not like he intended to commit the murder, right? An expert just can't come up here and be like, yeah, he had the requisite mental state. He was in that mental state and like he did it, right? So it's basically kind of just offering the expert and like the expert just checks one of the boxes of like he had the mental state. Like you can't do that in a criminal trial. In a civil trial, a lot of times experts will come up there and kind of give you their ultimate opinion. They'll be like, this person was negligent because of blah, 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 right? You have to lay the foundation to be able to do that. But in a civil trial, more things kind of go because the stakes usually are lower, right? No one's going to jail usually, or, have a conviction on the record type of situation. So that's just kind of how it is. But again, you shouldn't just kind of allow people to do these things. You should just, there is like an objection that's called objection, like this is an ultimate issue, right? Something like that. For example, if something were to pop up in a criminal trial where they talk about the mental state, or again, if there's just lack of foundation where they're saying like they're negligent and they just kind of leave it at that, it's like, well, there's a lack of foundation there, right? And lastly, 705. So disclosing facts or underlying data of the expert's opinion. So unless the court orders otherwise, an expert may state an opinion and give reasons for it without first testifying to the underlying facts or data. But the expert may be required to disclose those facts or data on cross-examination. So what this basically says is that the expert can kind of give you broad strokes of what happened and like what he used to come to the conclusions. He doesn't have to give you every little thing that he used to come to the conclusion, right? So if you get an objection, if you're directing an expert, you get an objection, lack of foundation because we didn't see, I don't know, there's a specific fact that he used to come to this conclusion, then you can say, Your Honor, under Rule 705, we actually don't have to disclose every fact that the witness used to come to their conclusion for this case, right? We have laid sufficient foundation. He's testified that he's an expert, but he doesn't have to like disclose all the facts type of situation. And you can even say like, Your Honor, opposing counsel is free to cross-examine them on these facts if they want to, right? And that also gives you a shot if for whatever reason the judge later doesn't want you to like outside the scope objections. If you can point to it, a lot of times some judges, well, in mock trial, this is more of a thing because you can't recall witnesses. In real trial, you would basically be limited to the actual like direct, and then, okay, I go do cross, and usually you cross on whatever the direct was. In mock trial, you kind of have free reign as to, cross up whatever. But if for whatever reason the judge tells you no, obviously direct them to say like, this is mock trial, we can't recall witnesses. And two, based on 705, I can ask them as to the underlying facts and data that they use to come to their conclusions. Does that make sense? Maybe that didn't make sense. Cool. Okay. Any questions about anything? Doesn't have to be about this stuff. It can be about another rule. If you're not fuzzy on it, I can go on talk about other rules. No? Okay. I guess then